So let's go over this video about this guy's diagnosis. This is my second video.
Let's go over Lane Myers. This is now the second video. I found that there were a couple of criminal cases filed against him last year, and he did a marvelous job getting everything tossed.
And he's right. He did a marvelous job. Like talking about Lane Myers did a marvelous job of getting them tossed. Now listen to what he says.
I don't know any of the background of this, but here was one example where he was contacted or a citation issued by the University of Arizona Police Department. Well, I saw a video on his website where he went to the University of Arizona Law School, and I don't know if he actually got busted while he was there, but says failure to comply with a court order. Anyway, dismissed. And the lawyer that he had is the lawyer he has on standby counsel now.
So he's saying the lawyer that he had is the lawyer that he now has on standby counsel, which is William Parvin, which was appointed to him at his arraignment in March of this year.
First, and then I'll talk to you about your motion. So is your true name Lane Jeffrey Myers?
You want me to sit down?
You can sit down. You can be seated.
Yes, ma'am.
Okay.
Listen to this, dude. This is so bad. She says on the document there in front of you, those are the charges, right? So she doesn't even say out loud what his charges are at an arraignment, but she says your attorney has, right? Like that is his attorney. And then after she claims that that's his attorney, then she appoints him that attorney. She tells him it's his attorney before she informs him that she's going to appoint him as an attorney. Let me explain this a little better to clarify myself here. So at an arraignment, the state has one job and one job only, and that is to make sure that you are clearly aware of what your charges are and the nature and cause of those charges, right? Which normally they do out loud by asking them and, telling them what the charges are. Instead, this lady points to a stranger, says, that's your lawyer, and the packet of information he's holding is what you're being charged with, and then tells him that lawyer's name.
On the document there in front of you that your attorney has with the criminal charges filed against you, we are going to enter pleas of not guilty on your behalf. I am going to appoint OPAC attorney William Parvin to represent you for now. I'm going to assess $400 in attorney's fees.
Okay, so the lawyer, William Parvin, was appointed by Judge, Miller, I think, 4 weeks ago. Or was it before that? So remember now, anyways, just listen to what he says. I have another hearing to go to. I have a hearing at 10. So he's literally, right after this, he's going to go to another hearing. But instead, he gets illegally kidnapped. The judge decides to break all the rules and have him kidnapped under a charge he can't even be charged for.
A hearing today or letting you talk all day? I got a hearing at 10.
Mr. Myers,
I have another hearing at 10. You're wasting my time.
Again, Mr. Myers,
This isn't your world. This is your
one warning.
Where's the Zoom?
That you are violating the forms of the court.
Why can't my family be on Zoom right now?
Explaining what the rules are.
There's no rule that my family can't attend on Zoom. Keep going.
Myers, if you keep interrupting, I'm going to hold you in direct contempt of court.
You don't scare me, bro. Let's do the hearing.
All right, I'm holding you in direct contempt of court at this time. If you can take him into custody, I'm going to, in the interest of justice, I'm appointing you a Mr. William Parvin to represent.
Most people don't remember that because it was literally one sentence of all the shit that happened that day. And on top of that, nobody could get on Zoom because this was a secret hearing of some sort. So his family couldn't get on. I couldn't get on Zoom. Nobody could. So almost nobody has seen that or heard that. But so William Parvin was really appointed back in December when this hearing happened. It was early December. So the date was December. It was either 5th or 6th. December 5th, I think, because December 6th was when he got released.
And you did it anyway. And you created this is a fucking game. I will expose you two motherfuckers for the dumb fucking cops you are. You fucking set that shit up ahead of time. You fucking knew I was gonna get arrested, and you knew I wasn't supposed to go to the fucking jail, and you did it anyways, and you created a fucking clusterfuck at your own fucking court because you're so fucking stupid that you fucking took me to jail on a charge that I can't go to jail for. And then the jail didn't know what to fucking do with me because you can't be in jail under ARS 12861. So they had to put a different charge on there. They had to make up a fucking charge to book me into jail on. That wasn't even the charge I was charged with. And then Judge Cornejo had to sort that shit out this morning because you dumb motherfuckers took a man to jail for a charge that is not a bookable offense. And you motherfuckers are gonna pay me a lot of fucking money for doing it. So how's everyone doing today? Is everybody having a good day?
Arrested by the court right before he had to go to another court, right? So a judge arrested him when he was on his way to court, basically. So I'm going to go start back over. We're going to listen again to what he says now that we know that William Parvin was appointed. The first time we heard William Parvin's name was on December 5th by Judge Ball after he kidnapped Lane.
Video. I found that there were a couple of criminal cases filed against him last year, and he did a marvelous job getting everything tossed. I don't know any of the background of this, but here was one example where he was contacted or a citation issued by the University of Arizona Police Department. Well, I saw a video on his website where he went to the University of Arizona Law School, and I don't know if he actually got busted while he was there. But it says failure to comply with a court order. Anyway, dismissed. And the lawyer that he had is the lawyer he has on standby counsel now. And then also last year, he got 3 other charges dismissed by the prosecutor, and disorderly conduct, criminal trespass, and the police, and again, it's out in Tucson. So whatever he did there, it worked marvelously. All the cases dismissed. Now that makes me wonder, and I'm just guessing here, did this embolden Lane that he could get away with?
No, I'm just guessing here, and I have no proof, but I mean, is it possible to time travel and for documents to fill themselves out with bunk information that only hurts a single person named Lane Myers? I don't know. People are emboldened by certain things,
Stuff, because ultimately the charges get thrown out anyway. I've seen clients like that where they say, hey, I got a great lawyer behind me. I'll just continue to do what I want to do.
I've had friends like that who used to have like a job that they thought was purposeful and realized that it wasn't, and then started getting online and making videos about stuff that they just, they just get online and lie about, So, I mean, that could be it. I don't know.
And
See, watch this slick move right here that he tries to pull.
And nothing really seems to happen to me. The question I have is, with 20 charges, are we dealing with just one victim, Shannon Walker, who I do not know? If I were Lane, and I'm not,
Sadly, this works on people because he's right. I mean, 20 charges from one person, you know what I mean? Like, that's crazy. But he wants us to think about that and wants other people just to be like, oh my gosh, could do government corruption. When really, secretly, he slides in the thing that he really means right there by saying the victim, Shannon Walker, because the whole crux of the case is that Shannon Walker is not a victim. But the way he mentions it by the wayside like that is like, you just assume that she is. And that's what he really was trying to say here. It had nothing to do with the 20 charges.
And nothing really seems to happen to me. The question I have is, with 20 charges, are we dealing with just one victim, Shannon Walker, who I do not know? If I were...
Yeah, this dude is absolutely a prosecutor. What he's doing right there is he was giving the police an option or a reason for unwanted investigation. Like he said, my question is, with the 20 charges that the court decided to put on him, are we talking about just one victim? So now the cops have a green light to go fucking through whatever they want and say, oh, we were just investigating to see if there was more victims. It's just covering for cops, giving them a reason.
And I'm not. And I'm not licensed in...
But that was genuine. The I'm better than you out of this side of my mouth chuckle. That was absolutely genuine. But the rest of this is just a lie, just to throw in that Shannon Walker comment.
I'm not offering legal advice in Arizona. I'm a California licensed lawyer. I'm just looking at this as a citizen who's speaking on a public issue about the constitutionality of speech and everything, which I'm involved in that all the time. How can you bring 20 separate charges involving, let's say, one victim, without it being a due process violation by effectively overcharging?
Okay, see, now this is what he wants to be the issue because he's obviously not paying attention, right? So like I just showed you, like Judge Ball just said, right? He appointed William Parvin on December 5th. Well, let's go back again in this guy's video and look at that very first piece of paperwork that he showed us. So the court set a court date for Lane Myers on December 5th, one with Judge Ball and then one right after that. And Judge Ball made the decision to arrest Lane Myers before his other court hearing, right? And now this dude has this piece of paper that says the lawyer that was appointed to Lane Myers as he was getting clinked into handcuffs is the lawyer that got these cases from October dismissed somehow, right? That's what they're saying. That's what they're leading us to believe. But I have a different theory, which I will show you.
let's go over Lane Myers. This is now the second video. I found that there were a couple of criminal cases filed against him last year, and he did a marvelous job getting everything tossed. I don't know any of the background of this, but here was one example where he was contacted or a citation issued by the University of Arizona Police Department. Well, I saw a video on his website.
Okay, so now he's going to start saying, well, I saw a video on his web, but whatever, who cares? Look what he's showing us. Check this out. The date is 10/18/2024, right? 10/18/2024. Honorable Judge Conejo. And look right here in the top, filed 10/22/2024. Okay, so according to this, the assigned judge is Conejo, and the date 10/18, and then it was filed on 10/22. So as of 10/22, this case was technically closed. And Conejo has never even been one of his judges, as far as I know. But anyways, that's what this says. So
Website where he went to the University of Arizona Law School, and I don't know if he actually got busted while he was there, but says failure to comply with a court order. Anyway, dismissed.
see, here's the thing. Lane was never going to let this case go. It was set for trial, or set for their hearing, and he wanted to be heard on the matter. The only way to shut him up or to get people to not look at this is to appoint William Parvin and then have William Parvin accept the dismissal or offer it and then get it dismissed overnight. You know what I mean? While he was in jail. And so it seems like William Parvin on 10/22, whenever it was filed, was his lawyer. But that's not the case. He was pro se, and he contested it, and he wanted the hearing. But this way, now he can't have that hearing. It also explains why this guy, Patrick, whoever, to him, it seems like William Parvin was the lawyer on 10/18/1022 when the actual charge happened. But he wasn't, because that was 2 months before anybody has even heard William Parvin's name. You know what I mean? For those, anyways. This is fucking insane. This is more than just a couple people or the cops or whatever. Like, this is like a deep, like rooted problem with it, and I think it has something to do with, or everything to do with the university college, dude. That's what I think.
The lawyer that he had is the lawyer he has on standby counsel now. The lawyer that he had is the lawyer he has on standby counsel now. The lawyer that he had is the lawyer he has on standby counsel now.
Anyway, but we do have this citation or the complaint number ending in 0014, right? And then what looks like the 13, whatever, A2 was the last one, what he was charged with, right? That's what it looks like. So now that first one ending in 0014, if you just take away those last four numbers, the rest of it is just the date. It's a date code, so check it out. These are the numbers before the 0014. And this is how you can check to see if they're being honest or not, because the actual date, as you can see, is 10/18/2024. So if you just take that first number, 241018, is really 10/18/2024, right? Okay, easy. Notice the little box that they've conveniently put in there for domestic violence related with a yes or a no box, so they can accidentally check that whenever they want. You know what I mean? They just put how can you have a interfering with a judicial proceeding domestic violence? If you're a proceeding is a court function, like when they say a court is in session, and then, you know, when a court's over with, the proceeding is over. How can you have a domestic violence charge in the middle of a court proceeding? And how can that charge not be the charge? The domestic violence charge be the charge? How is it interfering with the proceeding the one that stands out over domestic being violent? So too, here's another thing that's fishy. Below the box here, it says case events, right? And then it says like the dates or whatever. But if the case, he filed an appeal in the case, but if the case is closed, then how is the appeal still going? You know what I'm saying? And how do you close a case whenever it says the reason for is dismissed by the request or motion of a prosecutor. Okay. So as of 10/22/2024, the case status has been closed by Judge Conejo, who also happened to be the magistrate judge the December 6th morning whenever Lane Myers woke up in jail because he was illegally kidnapped by Judge Ball. And everybody was aware, and even the judge was put on notice that he had court right after that, right? So now, Let me explain what really happened with those dates, 10/18 and 10/22. So Shannon Walker on 10/10 who had an ex parte communication with the judge to get a court order to order Lane Myers not to be near the building, right, where she works, where, well, they served him supposedly on 10/17, but they didn't serve him. They served him with only the petition and not the actual order. So they said they made him drive down to the college to basically serve himself, knowing that he had to drive past that building, and they did. So on 10/18 is when they wrote this up, saying that he violated the court order, okay? It was closed on 10/22 because 10/22 is the day they arrested him for breaking that court order. So on the 18th, they knew that he drove past that building, which, again, is just ridiculous, but said that that's when he broke the court order. They waited 5 days to go arrest him when he had a court date. So again, he gets arrested before court, right? But this time they waited 5 days to strategically arrest him before he got to go into that court date. And you know what that court date was? That was the date he finally gets to have a pretrial and talk to the police officers that arrested him and find out that they're lying to him, right? He finally gets a chance to have his accusers in front of him, and he's arrested going into court. All right. This is all on the record too. So here's the on the record of him and the judge talking about it. Which, by the way, I've never heard the name Conejo, and I've been following every second of this whole time. I've never heard that name until today, or until I watched this guy's video. It was Judge Riojas that all this happened in front of. Now, remember, this is all on the record, and there was no objections to anything he said. So she knows for a fact it's all true. We know for a fact everything he's saying is the truth, because there was no objections from the state. The judge let it go. He didn't cuss. It's all good. Here we go.
Let me go for, let me get started. We're here in the matter of State versus docket numbers 2401966, 2401967. State announces presence for the record.
Sure, Judge. MJ Rossetti, RACITI, representing the state of Arizona. Ronnie Byrne for the state.
And Mr. Myers.
What was the second one? I didn't get.
Burns, correct?
Without an S.
Burn?
Mr. Myers is here representing himself, is that correct?
Yes, sir.
Okay. This is a status hearing.
Can I, before we move forward, can I make a little statement about last week, just to get me on the record? Because I heard you guys is on the record about it.
Sure.
Right now?
Sure.
Thank you. So, as far as I'm concerned, I know that she said that she had nothing to do with it, but let's break this down, sir. And we can only go by people at face value. You say you have nothing to do with it. You've been here 25 years. And I've talked to everybody in this building, everybody at the other courts. Normally they let me normally you do the hearing and then you get arrested.
Sure.
That's standard procedure, right?
I agree.
Okay, and so let's go over why.
This is why I like this judge, because he just became human right there. Like what they were agreeing with and having a little smile about. I know you can't see it, but is that Lane Myers has had this happen to him, and the judge has seen it so many times that they both instantly know that, you know what I mean. Of course, I should have waited till after the hearing, because Lane's like, that's what happens to me, you know what I mean, and the judge is like, I've seen that a bunch of times. I just thought it was cool.
Why I was arrested, because it's relevant to the record in this case. So at the last hearing that you and I had with Matt Walker, he attempted to go on the record, to get this court, you, sir, to order me to not be able to make videos, to not talk about the case and do all this stuff on social media. You told him it's my First Amendment right. As long as he doesn't, you told me be careful because there's laws, don't go, keep it into the area of free speech. All right, cool. So what do? Matt Walker leaves here. He goes and gets an ex parte, I believe unlawfully, they made the same exact arguments they made to you, unsuccessfully. They went over to Superior Court and they convinced ex parte. They manipulated a judge at Superior Court to give him an injunction against harassment against me, okay?
I just want everybody to be aware. This is before he had the recording of that ex parte communication. He didn't even know that it was. He didn't know anything. This is him just calling this out like he thinks what happened. Now it turns out it is what happened. But this is before there was a recording or even knowledge of the recording or even knowledge of the ex parte. He didn't even know that. Like it could have been anyway.
One voicemail on on Matt Walker's voice. One voicemail. Never met this lady. Never talked to her in my life. Left one voicemail. And I believe the state was deeply involved in this. It's Matt Walker. I'm not saying this woman sitting right here next to me, but I'm saying, remember now, they just brought her in. If you remember, last hearing was Matt Walker. So stick with me here. So Matt Walker, you denied him all his, you said, as long as he doesn't break the law, right, cool. So they go over there, the judge over there, female judge, for the record, gets manipulated into believing that I'm harassing somebody who I've never met, left one phone call on their public mail, right? Gives them the injunction. They claim that, okay, then they serve it, but they forget to serve. The server came to my thing, gave me the petition and not the order. So on Thursday, the day before, or excuse me, because remember, this was on Tuesday. So Thursday the 17th, a process server comes to my house and is supposed to be serving me this injunction. Goes to my house, leaves just the petition, not the order. Next morning, it was in the afternoon, I went down to Superior Court myself, drove myself to Superior Court, and I said, I have an injunction, give it to me right now. Hand it to me. Sign it, serve me. We did that. So on my way home, I drive past, the injunction said that I was not, did you go to U of A, sir?
Yeah.
So the law building, the Rogers Law Building, right? The law library building, right? So the injunction said I was not allowed to enter that building. Well, on the way home from serving myself the injunction that said I wasn't allowed to enter that building.
Your Honor, I don't want to do it.
Why is she interrupting me right at the most important part? Is this an objection? Then state objection. State objection.
Your Honor, the state is concerned that facts will be adduced at this moment in life, and I don't want him to incriminate himself.
I'm not worried about all that. I'm perfectly, thank you. Thanks for the free legal advice. Sit back down. And now, you should take your own legal advice and dismiss this case if you're worried. And so back to what I was saying, on my way home from getting the injunction, I drove past the university. You've issued injunctions in your 25 years. If you say you can't be within, so I drove past the university on my way home from Superior Court on Speedway. That was on Friday the 18th. So I come to your court date on the 22nd. I walk in here and there's the SWAT teams waiting to arrest me for violating the injunction for driving past the building 115 feet away. So we couldn't have court last week because I drove past the law building 115 feet away in my car, never stopped moving, never got out of my car. And that's why the U of A arrested me. Why did they wait 5 days, sir, so the violation occurred on Friday the 18th. Why did they wait strategically till I was 9 a.m. at this thing? If I was out here harassing people, violating court orders, and they knew about it, why'd they let me go out 5 days? Bad things can happen in 5 days, sir, Somebody's out there harassing and threatening. You can't just let this madman walk around for 5 days. Why was it strategically, without your knowledge, without anybody's knowledge, executed on behalf of the prosecutor's wife as I walked into my evidentiary hearing where the police officers were going to have to go under oath and testify to that way the evidence and all that? Suddenly, and here's the most telling part, sir, and I'm waiting on the body. The arresting officer was not here. So if I wouldn't have got arrested, he wouldn't have been here. The other ones were. The witnesses were here, but not the arresting officer.
It's his. Anyway, he's saying that no matter what, even if he didn't get arrested, that the arresting officer wasn't going to be there, so it wasn't going to be really like. And I think the reason that he wasn't there is because he doesn't have to be, because he signed a victim that he's a victim of the disorderly conduct, so he doesn't have to be there. That's what I'm contesting. But
you've seen it all. Why was their only goal, sir, was to stop me from that hearing, from putting that cop under the witness stand, under oath. And look at the lengths they went to. I'm not going to be found guilty of the violation. I should have got due process, right? It's because it's alleged that I violated it, right? So, allegedly I violated it. They took me to jail for a civil thing that's the equivalent of missing jury duty. Literally, I wasn't a fugitive from murder. The FBI wouldn't even arrested me right there. They would have let me finish the hearing. You know what I'm saying? So for some reason, they're claiming, we had nothing to do with it, when literally it involves the prosecutor's wife. And they went and got that because you wouldn't do it. You wouldn't issue the order. So they went and got Superior Court to get an injunction harassment and then said I violated it by driving past the building. Well, I drove past the building on the way here. Why aren't they here? You get what I'm saying? I drove past the building on the way to this hearing. So I'm expecting them to show up and arrest me in any minute. Do you get what I'm saying? It's hypocrisy. I can't drive down the road. And then now my evidentiary hearing, we're almost at 180 days. Look what it took me to get that evidentiary hearing. And so if this is not...
So 2 times now he has been arrested by the court right before a court date that court set for him to be at. And both times were under the either direct a direction of the court when Judge Ball directly said you're in direct contempt, guys, got his goons to go arrest him, or again directly from a court order that they said he violated, and then waited till he went to the court room for the court date that the court set up for him to have court. They've done this to him twice. Courts have set him up to get arrested either at court or in court. Now look where he is. How did his recent situation happen? Well, the prosecutor sent him a thing that said you have to come. You have a summons to appear, and then when he got to that summons to appear, there was 14 felony charges, and then cops waiting at the door to arrest him when he walked out. Come on. 2 more things that are super, super sketchy. Number 1, this guy, Patrick, whoever, brings up the fact that there was a process server that served him a piece of paper, right? And what he says the process, because the dude knocked on his front door and Lane said, basically get off my yard. I could shoot you in the face if I wanted to, blah, blah, blah. But anyway, that and this. It says online services, case types, forms and filing fees and all that stuff, right? Well, whenever I go back to... That's what they look like when you're on the website or the internet or whatever. Another thing is, why didn't he scroll all the way down? Because when you look at it on the website, I mean, and this isn't even a records request, this is just the website. So, I mean, but look what they show. These 2 things, the citation date and the date event or whatever, case events, but what he's not showing is this, where it says documents, and then it actually has the court documents to back up all this bullshit, and it even says available at courthouse. That's below those first 2. So why is this dude only showing us these 2? I'll answer that question for you, because the court documents can't possibly back up something that this guy is alleging, because he didn't have William Parvin for a lawyer, and because you can't time travel. It's impossible. Time travel is impossible. But what you can do is get a piece of paper or pull up the website creator and then just click a couple buttons, and it'll seem like that time travel is possible, but it's really not. Just like how they want us to believe that Lane Myers is like Magneto and can communicate with people just with his thoughts, because he's in a fucking cave. He's in a cage right now. He can't communicate with anybody, but that's what they're telling everybody. These people are crazy, dude.
That makes me wonder, and I'm just guessing here.
Yeah, here's what makes me wonder, and I'm just guessing here, but looking at these, sorry, this one that we were just looking at is filed on 10/22/24. Now, why on these 3 did he block that out?
Other charges dismissed by the prosecutor,
and blocked out the assigned judge's name. Why? That's pretty weird, right?
So whatever he did there, it worked marvelously. All the cases dismissed. Now that makes me wonder, and I'm just guessing here.
So, it kind of makes me wonder too. There was a comment on my page that said, Patrick, this guy was wrong about the Hendry thing. And it started to make me wonder, why is this dude talking about... Don't worry about that. I want y'all to listen to this audio for a minute. Just real quick.
Seminar today addressing the ins and outs of the new Arizona Rules of Procedure for Special Actions, which will take effect on January 1 of 2025. So just in a couple of months. Thank you for joining us today. We hope that the information and materials that are provided to you are valuable and informative to the work that you do, whether as a practicing attorney or a judicial officer. I'd like to give a little bit of background about how we got here. So on August 4th, 2023, then Chief Justice Robert Brutinel issued an administrative order establishing the task force on rules of procedure for special actions. And the task force was asked to restyle the current special action rules in conformance with the current rules restyling conventions, and also to make recommendations on substantive changes to the rules. The administrative order, the chief's administrative order establishing the task force, noted that the rules of procedure for special actions were adopted in 1970, more than 50 years ago, and that the rules would benefit from restyling. In addition, the chief asked the task force to pay particular attention to case law on special actions that has developed over the last 50 years. The administrative order also noted that the recent addition of 6 judges to the Court of Appeals presented an opportunity to evaluate whether the special action process can be more efficient and streamlined. In addition, the chief asked the task force to consider optimizing the use of court resources for processing special actions. There were 19 members appointed to the task force, with me serving as chair, and the task force members were fantastic. It was a broad cross-section of practice areas and geographic areas throughout the state.
This video right here has nothing to do with the audio. I just put this pretty people talking over the audio of that. But so, and like you said, that was for this to do stuff with a special action, like when you put a special action on something or someone, because like she said, from the set, blah, blah, blah. Okay, so, and this is before the 125, whenever the rule is supposed to change or whatever. This is just the task force lady just talking about it, okay? But here, so watch this. And like I said, this is happening everywhere. Here are a couple examples of what I'm talking about.
Wait a minute. Can you hear me? Wait a second. Is this still recording? Can you hear me right now? What the? And so I published that video on April 8th. Well, on April 9th, there's a brand new warrant issued just for Christian for the crimes of harassment and stalking, along with 8 protection orders from 8 different Jonesboro police officers.
Harassing, stalking, 8 protection orders because of YouTube videos. This sounds familiar. Oddly familiar.
Detective targeted Wolvie for his history of filming them and not identifying himself.
I don't know if you know this, but in the New Mexico kidnapping, when Lane got kidnapped by Moreno, Lane didn't identify himself either all the way to the jail.
Both of which are protected actions. And finally, there's the chief's unprofessional, biased, and factually misleading statement, where he claims that Wolvie is well known for his belligerent harassment of others. But Wolvie has never been charged or convicted of harassment. The chief then claims to support freedom of speech, but then completely undermines his claim by his contradictory assertion that others have a right not to be harassed, without providing any evidence that any harassment ever occurred. He ends the post implying that Wolvie is a liar and
it's a request. I can deny your request. I only have to follow the law. But I'm not going to waste my time with this. As many of you know, I haven't been allowed at many council meetings recently. City Hall, the police station, denied services for my township. And for what reason? Through the chair to Captain Ravel. Not attacking you, but for what reason? The business administrator filed a frivolous report against me, a VASPA order. A VASPA order is a shield for sexual assault victims, and instead, Edison Township used it as a sword to go after a critic of the government. Shame on all of you. I beat that VASPA order.
Similar to what I'm talking about with victims' rights in Arizona.
I have a copy of it here, if you would like to make a copy of it. Absolutely disgusting.
You see how the ironic hypocrisy here, right? That the courts can be ahead of a rule even becoming a rule, right? And they can get these orders that are to keep you from preventing crime and arrest you before you even do a crime, but whenever it comes time for like your day in court, they're years behind, and they only have VHS tapes and VCRs. You know what I mean? You know what I'm saying? It's absolutely disgusting.
I did not meet any of the criteria for a VASPA order, yet for whatever reason, The BA marked down lewdness, sexual assault. Are you kidding me?
This is in New Jersey now, but what I heard about on the other side of the country was a guy who had the same thing happen to him where a cop accidentally wrote down that he was a boyfriend and girlfriend with this lady that he didn't even know. And then also, too, later on to find out that he was charged with domestic violence and was accidentally checked a domestic violence box, when he wasn't violent at all. It's just weird how it's just happening to somebody else on the other side of the country who's not violent either.
Stalking and cyber harassment? And my only interactions with her are at this council meeting?
And the story that I heard, this guy didn't have any interactions with her. Crazy.
The chair to Councilman Brescher. I remember you making those statements of the attorney spending hundreds of thousands of dollars to find ways to keep me from coming to these council meetings.
Y'all think I'm crazy? So that audio we were listening to about the lady that was talking about the task force on the rule change 2 months or 3 months before the rule change even happened. Let me show you the video for that. What's 96 plus 17? Whatever the answer is, that's how many judges and judicial officers were on this Zoom call from that audio that you heard from that lady talking about the rule that hasn't changed yet. So think about that. There's only 50 states. So you could have one presiding judge in each of the 50 states twice on this phone call, plus other people, plus whoever's just watching their computer screen. If they're, you know what I mean? Potentially, this Skype call, or Zoom call could have been heard by every single state's judicial, like controlling judicial branch, judiciary. Every state's judiciary could have heard this phone call. Think about that, dude. And judicial officers, doesn't even mean just judges, judicial officers. That could be anybody in the judiciary. I'm just saying, man. It's whatever. This video's getting too long.
Chief Justice Robert Brutinel issued an administrative order establishing the task force on rules of procedure for special actions. And the task force was asked to restyle the current special action rules in conformance with the current rules restyling conventions, and also to make recommendations on substantive changes to the rules. The chief's administrative order establishing the task force noted that the rules of procedure for special actions were adopted in 1970, more than 50 years ago, and that the rules would benefit from restyling. In addition, the chief asked the task force to pay particular attention to case law on special actions that has developed over the last 50 years. The administrative order also noted that the recent addition of 6 judges to the Court of Appeals presented an opportunity to evaluate whether the special action process can be more efficient and streamlined. In addition, the chief asked the task force to consider optimizing the use of court resources for processing special actions. There were 19 members appointed to the task force, with me serving as chair, and the task force members were fantastic. It was a broad cross-section of practice areas and geographic areas throughout the state, judges and attorneys, prosecutors, and defense attorneys. And in fact, I'd like to acknowledge the task force members. I'd like to acknowledge the task force members, all of them. It was a fantastic group of people who put a tremendous amount of effort into.
Oh my God, dude. This is the part where they just take turns jerking each other off. It's retarded. I hate this part. But anyways, you see now how it's not so crazy to think that these are all, I wouldn't say related, but happening because of each other, dude. I mean, just think about it. Anyways, here's another thing that I thought was weird. Judge Metcalf, Doug Metcalf, is proposing another rule change because he doesn't like what they've done. He wants another rule change to this.
That needs to be, yeah, sure.
All right, go outside.
Turn off your.
I don't need to turn off my recording.
Yeah, it has to be on your person.
Then I'm not, then I'm just leaving. What am I signing?
Sign right here.
If this isn't on the record, you're getting sued, you know that. So I'm gonna leave it right there. You don't get to tell me I don't get to put an exhibit in because I hurt your feelings, Your Honor.
Look behind you.
See you in court, Your Honor.
I'll be filing the appeal when I walk downstairs. Notice of appeal will be filed when I get downstairs and the special action against you. So is that getting in, or I need to put a special action on that too? Downstairs and the special action against you. So is that getting in, or I need to put a special action on that too?
Please leave, sir.
Is that being taken into evidence or not?
You are violating a court order right now by not leaving.
Hold me in contempt, bro. I dare you.
By calling me bro is very disrespectful. By cussing at me and throwing things at my staff. All right, if we can have the minute entry note that the defendant has left. If the minute entry can note that on his way out, the defendant repeatedly cussed at the judge. If the minute entry could note that the defendant, what is that called? A flash drive towards my staff. If the minute entry could note that the court repeatedly ordered the defendant to leave after warning him that he wasn't following the rules. He failed to do so, continuing to violate a court order. I'll now continue to explain my thought process. I'll add to the credibility determinations the defendant's conduct on his way out lends to my credibility determination about him that I do not find him credible at all. The other case that supports my application of ARS 13-2921, I think is State versus Snyder.
Let the minute entry show that the unethical judge is practicing law from the bench. Also, let it show that there's nobody in the courtroom except the Tucson City prosecutor and his wife. And they're going to be communicating with each other, which I think is some kind of ethical violation as well. Let the minute entry show that the unethical judge, who actually is quoting a Supreme Court case right now, is not only practicing law, but he's quoting one that is not to be cited at all, ever, because anyways, just let the minute entry show all that stuff.
That is 2024 Westlaw 342301, and specifically paragraph 16. That case talks about the defendant posting videos, and talks about several people contacting the plaintiff about the videos posted by the defendant, and talks about holding the defendant responsible for the resulting communication of those third parties not being so extraordinary that it would be unfair. So I think that case supports my factual findings. I do think that all of these acts that I've mentioned were directed at the plaintiff. I can totally understand why she is alarmed, scared. I think not only a reasonable person would be, but I think almost any person would be. I think it'd be unreasonable not to do. I'm finding that there's no legitimate purpose for any of these contracts. And in fact, I'm specifically finding that I think the defendant's purpose is specifically designed to harass and bug and annoy. And I think his conduct during this hearing has confirmed that. That said, the order that I've sent, and I'll make sure that the plaintiff gets a copy of the order that I've signed, does affirm that the defendant is to have no contact with the plaintiff, not to go near a protected location. The other orders is what I've changed. The defendant must have no direct or indirect contact with plaintiff through any form of social media. That was basically in there before. Defendant must not post or place plaintiff's contact information, including her work information, on any social media platform. Defendant must not, through social media or otherwise, directly or indirectly encourage third parties to contact plaintiff or to go to a protected location. What I'm trying to do there is balance, put different wording in there. He has chosen not to participate anymore in the hearing, so to the extent he had any insight on that, or we don't have it, we don't have the benefit of it. Ms. Walker, anything I'm missing, more of a record or findings that you want me to make?
One thing that, Your Honor, I have wondered about, just that goes to my fear of Mr. Myers, is that I don't believe he's been ordered to not have any weapons. I don't know if that's something that can be considered, but that's something that was not part of the original injunction against harassment.
I didn't hear any testimony or evidence about guns or flashing guns or anything like that. I'm reluctant to do that without that sort of...
Okay, I understand.
I hope it doesn't happen, but if it does happen, feel free to come back and ask for a modification.
Okay, thank you, Madam.
Anything else that you want to do? Any other findings that you think I should be making? If we anticipate the appellate court is wondering what I did and why.
Your Honor, I do have a question about the current videos that are still displayed on Mr. Myers' YouTube channel that violate this. I understand that things that are outside of protect order are not considered, but he has violated this probably more than a dozen times with additional social media content. Is there any sort of consideration for him to be required to take those videos down that do display my contact information? Because unfortunately they do continue to encourage people to reach out to me as recently as today to harass me.
Yeah, these two look like real victims. Blah, blah. Makes me blah, blah. Oh, sorry, I just threw up in my mouth a little bit thinking about that.
Of course. Thank you.
It must be a first.